Whenever you sign a contract, do you ever get that nagging feeling you might have missed something? Well, it turns out some of the most important rules in an agreement aren't even written down. We're about to dive into the really fascinating world of contract law's hidden terms.
And that really makes you wonder, right? What if the most crucial part of a deal isn't in the fine print, but it exists completely between the lines?
This is exactly where the law steps in with something called implied terms. Think of them as unwritten rules that a court will read into a contract, kind of filling in the gaps the parties left open. And there are two totally different ways this can happen.
All right, first up, we have terms implied by fact. This is the category that probably makes the most sense right away. And it's all about figuring out what the people involved actually agreed to, even if they never said it out loud. So think of it like this. A term implied in fact is a part of the deal that was so obvious, the parties didn't even feel the need to say it. The court's job here is just to enforce what it looks like they intended the whole time.
So how does a court read minds? Well, they can't. But they have come up with two really clever tests to try and uncover these unstated intentions. On one hand, you've got the business efficacy test. This one basically asks, is this term so essential that without it, the whole deal just makes no commercial sense? It's like the does this even work test? Then on the other hand, we have the officious bystander test, which I gotta say is my personal favorite. This one asks, is the term so blindingly obvious that if some nosy bystander were listening in and asked about it, both parties would immediately say, well, yeah, of course that's part of the deal. And this old legal quote just nails it. The idea is that if that bystander pointed out the missing term, the parties would get annoyed and shut them down with the quick, oh, of course, it's that obvious.
So the main takeaway here is that terms implied in fact are all about looking backward, almost like a detective, trying to get into the minds of the people who made the deal to figure out what they really wanted.
But what if I told you there's a whole other category of these unwritten rules where the court, frankly, doesn't care what the parties intended? This is where it gets really interesting. And that brings us to terms implied by law. These are terms that get inserted into a contract not because the parties wanted them there, but because the law itself demands it.
Yeah, you heard that right. In this case, it doesn't matter one bit whether the parties intended to include the term. The law imposes it from the outside, usually for bigger reasons, like public policy or just plain fairness.
So why would the law do this? Well, a lot of the time, it's about leveling the playing field. It's about protecting someone who might have less power in a negotiation, fixing unfair power dynamics, and just making sure all contracts live up to some basic community standards of what's right.
Okay, I know this can feel a little abstract, so let's make it real. There's a famous case from the UK that just brings this whole concept to life. We're talking about the case of Liverpool's City Council versus Irwin from back in 1976. It's a dispute over public housing that went all the way to the highest court in the land. So here's the story. The city council owned this tower block, and it was just falling apart. The tenants argued that the council had an unwritten duty to keep the common areas, the stairs, the elevators, in decent shape. The council fired back, saying, hey, look at the lease agreement. It's not in there. But the court disagreed. They ruled that yes, this duty to repair was part of the contract, implied not by fact, but by law. And what's really fascinating is why the court said this. They were very clear this was not a term implied in fact. No way. It actually failed the officious bystander test because it just wasn't obvious enough that both sides had silently agreed to it from day one. Nope. Instead, the court basically just inserted the term for a totally different reason. They did it because it was necessary to make sure the property met the basic standards of living. This wasn't about what the parties intended. It was a policy decision about the fundamental duties of a landlord, no matter what the piece of paper said. So you see, we have these two completely different kinds of hidden terms. And understanding the difference is so important for seeing how contracts actually work. It means your agreements might come with protections or obligations that you never ever even thought about. This table really breaks it down nicely. Terms implied in fact, they're based on what the parties probably intended, all to make the deal work. And they come from the specific details of that one case. But terms implied in law are based on public policy. They're there to protect people and ensure fairness, like with the tenants. And their source is the law itself. If you remember just one thing from all this, make it this. One of these hidden terms looks inward, trying to figure out what the parties were thinking.
The other looks outward, applying society's bigger values and standards of fairness to the deal.
And that leaves us with a final question for you to think about. From your apartment lease to the terms of service on an app you just downloaded, what unwritten rules, both the obvious ones and the ones imposed by law, are shaping the agreements you make every single day?